Now back to the show. This is The Law Show on CL 650.
That Pollock, having my baby. Welcome back to the Law Show here on CIL 650. Today's episode is all about estate law and estate planning with the incredibly capable assistance of John Lakes and John White from North Vancouver's LakesWhyteLLP. We were talking about science and the law and the fact that science is way ahead of everybody, politicians and lawyers included, because it's politicians that make the law eventually at a glacial pace usually. So when people try to understand what's going on with the law, we've mentioned, for example, BC people, anything to do with wills and estates now are governed by a new act called the Wills, Estates and Succession Act, or WESA. You'll hear our guests, John Lakes and John White, refer to this term WESA a lot. It's just the latest variation of estate law here in BC. But guys, a lot of people on the cheap like to do their own thing legally. They're not lawyers, haven't been to law school for 5 minutes, and yet they're going to go down to the drugstore or download something off the internet for $50, and they're going to put themselves and their family's future in their own very safe, capable, experienced hands. When it comes to children, and John Lakes, you've done a fine job so far of helping us understand how family law and estate law see children very differently. So how would a person trying to download a will understand any of that and get it right? A lot of them just say, well, if I die, I leave everything to my children. Sign here, and that's it. How smart is that?
Not very, but it could be very beneficial to some lawyer who has to go to court to interpret that will after you're died, or else it could lead to a lot of interfamily lawsuits and hardships and hatred and so forth. So the key always is to get a will done and get it done properly, and a will's not that expensive. So if you're in circumstances where there's some issue about the children, first of all, if you're actually on the birth registration as the parent, but you've never legally adopted that child, and you're not the biological child, then in your will you could say, I leave everything to my children, Mary, Frank, and Henry, and Henry's there. Even if you're not the biological father of Henry, you've defined him as your child.
Right.
Or else you could say, I leave so much to my stepson, Henry.
Right.
And you could also put in your will that you've included Henry because he's acted as a son to you. You've always considered him your true son, and through circumstances you were never able to adopt him. And then you have it in your will, so not only is it Henry is included, but the reasons you are there as well.
There's an understanding of why he's there.
And if you've got it, the reason in the will, it's there, as opposed to some journal that nobody can find, and a will, when it's signed, is not only signed by yourself, but it's signed by two witnesses.
Right.
So the important thing is, if you do a will, you do it properly. You make sure the people who you wish to benefit are beneficiaries. And third of all, if you need to leave any sort of message as to why these people are included or not included, you need that message to be found.
Okay.
And so for the cost of doing a will, it's a bargain compared to tens of 20s or 30s thousands of litigation and delay, and then you end up, some stranger will decide, and you're of course not there to give the evidence because you're up in heaven somewhere.
That's right. That's right. So typically, and I know there's not a one size fits all, that's what we're talking about here, but typically, John, what would putting together a will cost a person?
Well, I mean, generally under $1,000 probably.
Right.
There's always circumstances as to different costs.
And my sense of nasty is showing here, John White. But let's use this example, this family group. The dad, in his do-it-yourself will, has just identified the 3 children and what they're going to receive. The stepchild, we now know, has no standing in British Columbia law to say, well, I'd like a little more, or I'd like a little less. You can't apply to change or vary a will unless you're either the biological child or the adopted child. legally adopted child, right?
Right. Well, the spouse gets to apply as well.
Of course. I'm talking about children
spouse,
here. But I'm talking about the other two children. Have you ever seen a situation, it's all about follow the money, have you ever seen a situation where the third child, perhaps the not biological relative of the other children, is given some money, and the other children goes, wait a second, he's not a real family member. Let's just apply and get the old man's will changed and cut this kid out. He doesn't deserve a dime. Have you seen that?
There are all sorts of cases where groups of children fight each other. I mean, there are cases where the children of the first marriage fight the children of the second marriage.
That would appear to be more normal than, or more frequent than others, right?
That one comes up from time to time.
Sure.
And it really is always a question of, firstly, of standing. Do you have the standing to make the application, yes or no? And if you do, then the court is going to look at whether you have a legal or whether the will maker had a legal obligation to you or a moral obligation to you to provide for you in the will. And when you get to adult children, it gets pretty tenuous.
Right.
Most of the time, the will maker doesn't have a legal obligation to make provision for the adult children, and then it's all about what's moral.
Right, and John Lakes, you've told us about stories about a situation whereby the person dies, the estate is all the preparations are set to go, and I want to say adjudicator, and that's not the right word. The person who acts as your agent after you die, the executor is appointed and all that, and all of a sudden, out of the blue, appears an adult who lays claim to the estate. Hey, I'm the long-forgotten son that was born in another province 25 years ago. I'm here now. Where's my slice?
Well, that is a very interesting point, because if you're an executor of an estate, sometimes you have to do things that other people don't want you to do.
Okay.
But under the WESA, when you apply to be an executor of somebody's estate, you're required by law to send a notice to, first of all, anybody who's a beneficiary of the will, but also anyone who has a potential claim to the estate.
They all have to find out that you're the executor.
And they need to know what's in the will.
Okay.
And so the other kids say, oh, why, Sterling, should you bother with Frank? No one's seen him in 30 years.
Right.
Well, the point of, if Sterling doesn't deal with Frank, and Sterling goes ahead and distributes the estate to the other people and give them all the money, and all of a sudden Frank surfaces, then Frank's going to go after Sterling.
Right.
And so, I've had several cases where we've had people say, why do you have to tell them? Well, you have to tell them. And if you're not going to tell them, then you shouldn't act as executor, because the law is requiring the notice to be sent.
Right, right.
Because everybody who has a potential claim has to know about it.
Okay, but still, again, and John, help me with this, John White, because again, it's the unknown quantity here. It's the, what the heck? Who is this person? We've never seen this person before, and all of a sudden, he or she has what they're telling us is a legitimate claim to this. Who is this person? This happens.
Oh, sure, it happens. Absolutely, it happens. There are children from previous marriages. There are children from previous relationships that weren't marriages. There are children from one-night stands from the past,
right?
Who have, as long as they are natural children of the will maker, they have rights to inherit under a situation where there is no will. They have rights to seek to vary an existing will if they're not named. And they certainly have the right to know about the will, as John has said, and receive the written notice which the Wills, Estates, and Succession Act requires.
So a good little lesson to be derived from all of this, John Lakes, is if you are one of those people with, shall we say, a colorful past involving relationships with lots of people, and all of a sudden it comes time at that point in your life where maybe I should start to organize my affairs and maybe even consider putting a will together. This would be a good time to talk to a lawyer rather than going online and downloading some do-it-yourself nonsense.
Well, I've had more than one will where I've had, after I've seen the husband and wife, the husband phones me a week later. Says, well, my wife doesn't know about this, but. And you see, women usually know who their kids are, but, the fathers weren't. And you and I are sort of the age you can remember, while people were fairly loose in the 60s and 70s, and there's an awful lot of single mothers out there. There got to be some single fathers, too.
Mm-hmm. Mm-hmm.
And, the old term children born out of wedlock and these things like that. We all know friends who've always not sure whether they might have another child out there.
Mm-hmm. Mm-hmm. And these are the people who appear at the least convenient times going, well, here I am.
At least once a year, I have somebody phone me up and said, well, I've had this phone call from a 46-year-old person.
Right.
I said, oh, and who's their mother? And they said, who it is. And, well, could you be the father? And they said, well, and you asked the opportunities. And, in the last two cases, I then said, well, you phone her back and find out whether she was adopted by somebody else. In both cases, the child was, so they're off the hook.
Okay.
But
so the legal adoption relieves the biological parent of any responsibility.
That's correct.
Okay. You've said that before, but it bears repeating. Let me take a quick break, guys. Speaking of cases, we brought a bit of a case study with a sense of humor, and also we want to talk about more of this cutting-edge science law intersection of reproductive technologies. It's The Law Show with John Lakes and John White from North Vancouver's LakesWhyteLLP, and we'll be right back.
There's more of the show still ahead. This is The Law Show on CL 650.